It was one of those moments where you almost faint. To hold in my hand a copy of a document that the district attorney at the time had and didn't tell anybody about it on the defense side.
That document would have proved what?
Would have proved that Michael Morton is innocent.
He's talking about this police report.
Sitting in the prosecutor's file and sitting in the sheriff's file, there was a set of documents which, if they had been revealed and the defense had seen them, Michael Morton would have been acquitted. And this is a very important moment. We've had a whole series of cases in this country that have focused attention on this issue.
If you did those things, if you did the sort of stuff where you were hiding evidence from a homicide investigation, they'd lock you up in a minute.
The Commonwealth deleted information from the discovery responses. I don't know if it's done with whiteout or what method they used to redact it. In 07 CR, that should be 4123, the Commonwealth redacted contact information of Stacey Evans. There is a resident that is during a neighborhood canvass whose information they've deleted. Lanice Bell, Norman Martin, Connie Cherry, William Martin, Barbara Clay, James and Geraldine Ely, James Buchanan Jr., Tracy Meredith, Katrina Bell, and then in 06 CR 2087, again, portions of the statements of Latrina Bell, Barbara Scheckles, Stacey Evans, Troya Scheckles, Rhonda Rattler, Carrie Burks, Luella Hunt, Marshall Williams, Aisha Rhodes, Ann Jones, Erica Ford, and Timothy Cross have all had deletions or changes made to the statements, be they transcripts or investigative letters that are verbatim or alleged, I guess, recitations of what the witnesses told the detectives. We need to know that information so that we can help prepare the defense. This is a capital case. The Commonwealth is seeking the utmost penalty, and I think our ability to prepare a defense is tantamount here. That means that what the witnesses said is to be turned over, not an altered version. We don't have a way to get people's phone numbers, so we can't tell who's calling who. We don't even know what their discovery responses mean because they have deleted information out of it. If they would just give us what we're entitled to, then we would be able to decipher the phone records. We would be able to look at what the evidence is and what it means. There was some supplemental discovery that was given to the defense today. It's pages 481 to 491. It is more phone records from T-Mobile. They have deliberately, and it was deliberate because they have omitted and gone to the action of not just omitting it from their investigative letters and omitting it from the transcripts, but actually taking the physical witness statements, the tapes, and deleting the information from the tapes by recording blank space over it. I have expressed my concern to Mr. Van der Rostein. In addition, these records that were returned over to us on December the 1st are particularly concerning. These records were obtained in 2006. They were provided based on the cover letter that I believe is listed as page 481 on July the 18th of 2006. They were sent to the grand jury at that time in response to, I believe, a subpoena issued by the grand jury, dated June 26th. We didn't receive them until December the 1st of this year, so this would be a year and a half later. I'm sorry, 2.5 years later, I guess. Yes, 2.5 years later, excuse my math. I feel that the Commonwealth has gone through the actions of omitting this information. They've made it impossible for us in this situation to know the significance of what's been provided to us, and therefore extremely difficult to advise our client. But they've also had some of these documents and some of these records in their possession for 2.5 years. That they provide to us who these numbers belong to, the ones that, to their knowledge, they know, which we know they know because they've omitted, but what the Commonwealth has done here is actually changed the actual witness statements. They have altered them, they have deleted information, and they have changed the actual reports. They have changed the actual transcripts.
Judge, I'll be happy to. What happened was I've been going with my detectives, and there's another page we found. I'm constantly going back to the police and trying to make sure that in the exchange of such a wealth of information, well, you know, so many documents, so many people involved that we're always trying to say, look, did I get everything correctly? Do I have everything that you have? Do you have everything that I have? Constantly trying to make sure we're complying with the court's order. And so what we have to do, so we're always trying to go find the physical file, compare it, and make sure we've got it. I discovered when, in our preparation for trial, and it's further complicated by the fact one of the lead detectives in the Kerry Williams murders has since had to take a medical disability due to a closed head injury, and so her memory is not what it should be. She did suffer some memory loss, and so that always causes us concern, because then you're trying to figure out what means what. That's one of the reasons I found these in that going through the files the last few months that we're always going through, making sure we have all of the documents that we should have. And I'm trying to find out who subpoenaed these and when and why. I'll be happy to try to find out whose number it is and why someone subpoenaed these, but the list wasn't on it. I found them in the files, and I said, I don't know what these are, but I'm going to tender them because I don't want to hold out anything. But I'm still trying to find out. My problem again is I have a detective who may have knowledge of it but can't remember, and that's what I'm trying to track down.
And Judge, the other phone records I had also discussed, there's a page that was missing from the copy of discovery that was given to defense counsel in 2 indictments. 07 CR 4123. We were missing page 182 and 183, and I did not know if perhaps it's in the court's copy and it was not, for some reason, didn't make it to ours.
I had it in mind, which I had given to the court, Judge, and I'll be happy to copy that and forward it. But
Okay. If you wouldn't mind going ahead and sending that to
Judge. I thought I had, but if I haven't, I'll do that.
That's 182 and 183 of the 07 indictment.
7 case, yes.
Thank you.
And I'll tell him, Judge.
And there's one other matter that I discussed with Mr. Vander Rossum before we went on the record, and I think he's looking for it. The first two statements of first two pages of Mr. Hammond's statement, which would be we believe to be 182 and 183.
And Judge, what I did is I tried to bring as much paper discovery with me as I could haul over today, and I dug it out of the original discovery tendered in actually it was tendered in this court on January of 2008, and it's in my stamp copy. I don't know how I did make it in theirs, but I've given them those first 2 pages.
Yes.
So I went back and copied it right away.
That's it on that, Judge.
All right, what else before the court?
Judge, these, just for the record, we make one final motion for all discoverable evidence under RCR 7.24, RCR 7.26, and any and all exculpatory evidence previously disclosed.
Okay, Mr. Connell, have any additional
For the court
evidence?
today, Judge, we've got some phone calls. We have no idea what's on them. There's hundreds of them. We got these from the jail. I've never listened to them. I have no idea what's on them. We don't intend to use them in our case machine. But I have them, so therefore I'm turning them over.
Okay.
I don't know if they're inculpatory, exculpatory. They're a public record kept by the jail. We got some phone calls, but there's literally hundreds of these phone calls.
Okay.
I've never listened to any of them. I have no idea what's on them. So I found out that Detective Downs had some phone calls. I said, put them all on a disc and bring them to court with you today. So there we have it.
So that is one issue. The other is I've never heard these, but I moved to exclude them. I don't have time to listen to 1,000 jail calls during trial. And there's hundreds and hundreds, I suspect thousands of calls. They've been in the Department of Corrections forever. Apparently, we haven't heard how Detective Downs got them. I don't see a subpoena. But if she got them through subpoena, I don't know how long they've had these to hand them out on the day of trial and say we may impeach. There could be, I don't know what's on those calls, and I would move to exclude them immediately.
Some of these are over a year old, January of last year.
Rothstein, you indicated you haven't listened to them. You have no idea what's on them. They're just being turned over today.
I do not, Judge.
And, I mean, it would seem at this late date that it would be appropriate to exclude them. I'll give you the chance to argue otherwise, Mr. Vander Rossstein.
I don't know if we're going to, Judge, we're not going to go into the content of the phone calls. I think the fact that there were phone calls made, I mean, obviously, we know that people call from the jail and that they call people.
Why is it just, as a matter of curiosity, why are we getting this information on the day of trial?
Judge, I haven't seen them. I talked to Detective Downs, and she indicated she had some jail phone calls that were old, and they are old. And so I said, well, you better bring them to court. We're constantly searching for information.
Well, prior to trial.
Just a couple of quick things, Judge. One is they are not going to introduce these jail calls, but they, I guess, are supplying us to them. That's what's their representation, and that's also an
Which jail calls?
We tendered them today, Judge, and Judge, on the February 21st, which was the date we were originally scheduled for trial, I think it was either the day before or that day, we indicated we had these in our possession, and the court excluded them at that point in time because we were all under the impression we were going to start the trial that day. But we have them in our possession. I'm turning them over because since they are in our possession, I feel I need to do that. So we did that. Those records are now in possession of the court and both parties.
Those are phone calls?
Jail calls.
Jail phone calls, yes, sir, that are recorded.
Okay, so you're not, so the Commonwealth's not proposing to introduce any of those?
No, Judge.
But we're not going to introduce them in our case, Judge.
Okay.
Jimmy Hickman, Judge, they've had Jimmy Hickman's statement forever. We tendered it at the beginning of this case. To exclude what Mr. Hickman said is extremely detrimental. There's no basis in it.
Not all of them, Judge. There's a jail call, a partial transcript of which is contained on page 114 of discovery, which would arguably be introduced to rebut any assertion by the defense that there was some timing in terms of fabrication. That's very critical for the defense. To add that for the last 3 days, I've been asking for 2 jail phone calls.
After they brought that to our attention, I'd searched my files. Detective Stalvey went home last night, and he searched through all of his materials. He was able to locate those phone calls in which the transcript is contained within the discovery. But I never had them in my possession. I had that transcript in the investigative letter. We turned that over.
Your Honor, if the court looks at pages 114 through 116 of discovery, it is completely obvious that that is not a full transcript of either phone call, and either one of those calls or both of them. What little's there indicates there's probably some colluding going on. There is a basis for this. It's discoverable, it's exculpatory, and I don't know, I guess I'll just have to take the Commonwealth's word for the fact that it's inculpatory. But there's more than an argument that I'm entitled to it, and I still don't have it, and I don't know if I'm supposed to sit here and listen to it while people testify.
Is there anything else that Ms. Smith needs that we're going to get at the last minute?
No, Judge.
2 days ago, the court continued the trial for 2 days based on new evidence, or actually quite old evidence that's over 3 years old, and I got a disc with 266 calls on the disc, ranging from June 2008 to May 2009. The most important aspect of this evidence that is over 3 years old that I got on the second day of trial is the following.
They said it was some dude named Swing or something. Swing. I don't know, bro. They say he drive a truck. God, man. Yeah, he just had them all black and he just tried to kill them.
That's who did it, Judge. And I got this on the second day of trial. Not only that, but there's a video interview that was the subject of a suppression motion regarding identifications. I got that video interview last week. This call, when you put it together with that interview, tells you who did this. And my opening would have been completely different. I would have been able to say, not only did we not do it, but we know who did. And everybody else did within about 25 minutes of this trial. And it is my second motion for a mistrial. And that the video interview I keep referring to that I received last week, that person names who ordered this hit. And that person's street name is Crime. It is Ricky Kelly's co-defendant in federal court.
I'm interested in the motion for a mistrial right now.
I think I'm getting 2 calls. I get 266. There's a lot that I need to look into, and I couldn't possibly have known to do that before 2 days ago, the second day of trial. And my opening and theory would have been completely different in this case. People were talking about who it was right after it happened.
You want a while to think about it, Judge?
No. All right, I'm going to sustain your motion for a mistrial.
court can appreciate what we got on the first. This is more than any discovery we've ever gotten on this case. I got it on the first. It's over.
The first of
this month. It is over 3 years old, 4 years old almost at this point. This murder happened in March 09. The court may or may not be aware of what happened that resulted in the first mistrial, but for numerous days in a row, I kept referencing some discovery that we already had. There's 2 calls that are partially transcribed on pages 114 to 116 for 3 days in a row during the first trial. I kept saying, I don't have this. Where's these calls? Can I have these calls? Maybe there was a misunderstanding. Finally, when I made a motion for a mistrial based on a 2009 statement of another witness that I was given on Monday jury selection and heard one time through. Now, I hadn't even heard the whole statement as of when I came back and said, look, I need these calls or we can't, I'd move to exclude Dad and Jimmy's testimony. That's who the calls pertain to. And I suspected that probably they were colluding and getting their story straight. Well, the court gave me a 2-day continuance after I received a disc with almost 300 calls on it, containing 44 hours of discussion between not only father and son, somebody named Little Steve, who I believe probably was the one who killed this woman. I mean, this is the first phone call. There's a call 3 minutes after the first 911 call by Dad to his house where an eyewitness, little kid, is telling him what little he saw. He was upset, excited utterances all over the place. There's another call, and then another call, all the same people, and in this third call, about 30 minutes after the first 911 call, a female whom I now know is sworn to be here, but I didn't even know her name when I heard this. Said she names the shooter, where he's from, and what he drives. And I got that in the middle of the first trial. After I just was beside myself. I couldn't review all that information when I got a 48-hour continuance and I was given 44 hours of calls. I have now reviewed every single minute, and it's clear to me the real shooter's on there. Troya Shekels is on there. She's referred to. She talks on the phone. We still don't know who all the phone numbers are. That's the context where I'm beginning this motion, this second motion, to dismiss with prejudice. I know that one prosecutor is no longer on this case. This is outrageous. This is cell phone records for 11 accounts from 09. It's 4 years old. And there's no way that the Commonwealth thought they already filed that. There's no way. This I got on the 1st of May. All from 09, all cell phone account information. The court just sat here and listened to I don't know how many arguments about phone calls, and there has to be some showing they even happened. Well, if it's in there, show me, because I haven't had time to even look at it. And I've explained to my client, there's one thing I've learned about this case. If I don't have it, it's exculpatory. I don't know why, but I believe that. I fully believe that.
What's the nature of the phone calls?
I don't know. I know whose accounts some of them are, but because I have scrambled. It's like standing there watching a train coming towards your client really slowly, and you're so inundated with information that you should have gotten when this case was indicted in 2011. There's no way I can go forward, but I shouldn't have to. You know, there's a 418-6553 number on the desk with 300 calls on it, whom I believe clearly the shooter's calling may be Troya Shekels. Nobody subpoenaed that number and its contents, and I don't know why. And I don't know if this is all there is. I don't know if there's more. And I have a basis to believe there is more. Digit number. Clearly, they issued numerous subpoenas in 09 to the grand jury. Not all of those numbers are accounted for. I don't know. I would request and make one motion right now for all discoverable and exculpatory evidence and/or everything you have, we need now. I cannot effectively defend him when I get inundated with 800 pages of records. This case is about phone calls. The whole case is about phone calls. I mean, I may well have the proof I need to show who really did this now. You know, I've been chasing aliases, researching Mugsplash for 8-9 months now, just trying to figure it out. It's probably right there, but I don't even have time to open this binder. I don't have time at this point to verify whose number I know is whose isn't, and I just got this and it's 4 years old.
Here, but I recall one of the cell phones was one that the subscriber information came back for him.
And that may or may not reflect whoever might have been calling him within the moments before and after this lady got gunned down in broad daylight, as we keep hearing over and over. Whether that number, if it is even in those records, because I haven't had time to look at them, exonerates my client, and that's why this is outrageous. This is 4 years old. It's 4 years old, and the last time I heard this song and dance, I had the shooter's name when I got done, lucky as I was, to listen to the right phone call out of those 44 hours. Just a very familiar feeling came over me when I got that the other day. But it's like being blindsided. I can't sit down and get ready to do jury selection when it is bugging the crud out of me that probably the shooter's in that 800 pages. That's what the Commonwealth does not get to do. And this is the second time that I have been blindsided like this, where I'm sat looking at one direction. Do I pretend this information just doesn't exist because I don't have time to sift through it? And it's going to take 2 years probably to go through it. They've had twice that much time at their leisure if they wanted to go through it. I didn't even know they had it until the 1st of May. That's what they're not allowed to do. And it's the second time it's happened. And it's more than fair to request a dismissal with prejudice. It's more than fair. This is more than twice what we've ever had in terms of discovery.
So we're not here, I'm not here this afternoon making excuses for the oversight, but I believe it was an oversight that it was in the box and had not apparently, even though it looked like it had been scanned in, it apparently had not been scanned in a way that preserved it and disclosed it.
And I mean, I appreciate the candor, but it doesn't change the fact, it doesn't change a thing I just said. It doesn't change a thing. We hear nothing but phone calls. This entire 2-3 hours has been about nothing but phone calls that nobody's showing any documentation on, and it's not in there, I guarantee it. And that's why we're not hearing about what's in there. Because I know, based on my experience with this case, that it will push us even closer to exoneration, because there is no case here, and that's why this keeps happening. But I think the circumstances here are egregious enough. Fine, it happened once, 4 years old. Subpoena numbers are in order. The subpoena number on my disk with the 44 hours of calls is 9230. The phone number on the front of that disk, which is one of 4 phone numbers on this disk, is 650-0234. There's 200 pages of records from that number in there. And I don't know anything, I wasn't even home. All this is now documented by these records, 200 pages right there. You're right, DeJuan Hammond is associated with 2, maybe 3 phone numbers. That's why it's so important. If my client's cell phone number isn't in there, not guilty. I just got it.
I'm going to try really hard to stay calm.
During the cross-examination of Princess Bowen, I believe Ms. Schaus, I don't know exactly how it was worded, but her first interview was on June 30th of 2011 with the police. Afterwards, he showed me an August 12th, 2009 interview. At that time, we went out to his truck and we pulled the interview. The portion of the interview was never filed, and turned it over to him about 30 minutes ago.
It is, of course, our motion for a mistrial based on prosecutorial misconduct. This is a residue of Mr. Van der Rostein's approach to this case. When they learned of it, when I was in the well cross-examining their witness, as Detective Stalvey touched him on the shoulder and said, "I've got this." This is page 44 of the discovery as turned over to us. And you can see it stops halfway down the page. This is the report we were presented with today. And halfway down the page, it says, interview of Princess Baldwin on Wednesday, August 12, 2009. And it goes on for half a page, and then another page, and then a little bit onto a third page. And I said, and Judge, you know, given the way the case has been prosecuted, given the fact that Mr. Petway's trial was a mistrial initially because of a failure to disclose, and then the whole dismissal because two witnesses couldn't be found, in quotation marks, caused a mistrial, I said, Judge, I want all exculpatory evidence in this case now. The Detective Stalvey went to his truck and found this. It's not the first time it's happened in this case. The exact same thing happened to Stephen Petway. Someone covered up that page when they ran it through a Xerox machine. There's no other explanation. This was done years ago. Give us all the exculpatory evidence you've got. Has anything changed with these witnesses? No. We've turned it all over. We've turned it over years ago. There is nothing. And now this, found in Detective Stalvey's truck.
I said, when I'm saying we went out to the truck, because that's where he kept his reports when he back and forth in court.
But the thing that's so troubling is, it's clear somebody made a Xerox of this and intentionally deleted the entire interview. That's a mistrial, because the defense counsel's opening would have been completely different, obviously, if he'd seen it. The whole complexion of this last 5 days of this case would have been completely different. Judge, there's no way to paper over this or to squint and look at it sideways and figure it out. You basically gave us 5 hours to deal with something they've had for 5 years. And another thing, Judge, I knew there was stuff out there. I knew they didn't turn it over. That's why on April the 3rd, the Thursday before the trial began, I said, Judge, please order them to turn over all exculpatory evidence. And you said, Mr. Lasowski, I want it by 5 o'clock tomorrow afternoon. Does the Commonwealth not have to follow any of the rules? Forget RCR 724, RCR 726, forget Kyles v. Whitley, forget Brady, forget the United States Constitution. Do they not have to follow this court's verbal order to turn over exculpatory evidence by 5 o'clock Friday afternoon? And another thing, how in the world can we possibly make hay with the fact that they prosecuted Stephen Petway with this in their possession? We're not allowed to get into his conviction. So now they're getting away with it when I could really hang him out to dry with that. You convicted a boy and sent him to prison for 55 years without disclosing this evidence. But I can't get into that either. This just isn't fair, Judge. This is a mistrial, and it's their fault. I'm sorry to be excited. I'm sorry, sir. I'm sorry to be excited, but this is not right. Just so the record's clear, Judge, I believe that the disclosure of this report is evidence that a crime has been committed. I think that's tampering with evidence. I've not heard anybody from the Commonwealth dispute the fact that somebody made a Xerox of a police report hiding a statement 5 years ago. I've not heard the Commonwealth object. They're not objecting now. They're not sitting here telling you that's not what happened, Judge. I mean, this calls for an investigation.
I acknowledged that and I think I told him when I showed it to him that it appeared that this was intentionally cut out for whatever reason. We recognize the defendant's right to Giglio materials, but I recognize and don't intend to step on the concerns that they voiced. It didn't occur to me till Sunday afternoon in my meetings that there was a report that had been deleted referencing the witness. It is indefensible whether it was done intentionally or whether it was done negligently. I've talked to Mr. Randy Rostein. I've already told the court he didn't recall the incident, and I recognize that in the middle of a trial, Giglio material coming out, I recognize, as I did yesterday, the error that occurred, take responsibility for it. It was my duty.
What offends me is that the Commonwealth is suggesting that we go forward with a prosecution where there has been criminally altered evidence. I think this court is aware that Mr. Schaus is pretty excitable, and I think I'm usually good at keeping that part under wraps. But how dare the Commonwealth put this court in the position of making this decision?
Well, I'm not
There's a prosecutorial duty to
I'll let
seek.
you respond in just a minute, Mr.
There's a prosecutorial independent duty to seek justice, but I just want to make the record clear that I am offended that the Commonwealth is not making a motion to dismiss this case right now.
I recognize the concerns that they have, and I've candidly recognized those in the front of this court, as I think I'm obligated to do to the tribunal.
Judge, if I might, that's tampering with physical evidence. It's not throwing a gun in the river. It's not burning bloody clothes. The evidence is the report. That's a crime, Judge. And I want to point out, tampering with physical evidence, you throw the gun in the river and the police they drag the river and find the gun, you're still charged with tampering, Judge.
Well, I'm not acknowledging a crime's committed for all the reasons that I said a few minutes ago. I recognize their characterization of it, but I'm just acknowledging it that it was intentionally not included in the discovery.